Hi guys, welcome to my channel once again. Thank you so much for always stopping by. Today let's talk about bail. What's bail? Bail is the release of a suspect or an accused person pending the determination of the case against him or pending investigations. So it's very simple. When someone is arrested or charged to court, you can apply for bail. You're simply asking the police or asking the court to release them pending the determination of their investigations in the case of the police, or pending the determination of the case against them in the case of the court. There are three types of bail. Bail could be police bail, it could be bail pending trial, and it could be bail pending appeal. Bail is a constitutional right. You find it in section 35 subsection 4 of the Nigerian Constitution. When it's bail pending trial or pending appeal, it's subject to the discretion of the court. It just means that the court has discretion over who it can grant bail or not, depending on the facts, the documents, the prayers put before it by the person's counsel, by the person's lawyer. For police bail, someone arrested by the police, a suspect, is supposed to be released within 24 to 48 hours, pending further investigation, especially for felonies and for misdemeanors. That's small offenses and felonies. But capital offenses are not bailable. Bail is free and it could be conditional or unconditional. If it's conditional, once the conditions set forth by the police are met by the person will be released on bail. So there are circumstances whereby someone cannot meet the condition for bail, or whereby it's a capital offense, or whereby the police has difficulty, bringing the person to court on time. In those three cases, the person will be remanded in custody. But ordinarily and according to the Constitution, a suspect arrested by the police should and must be released within 24 to 48 hours or charged to court for an offense, which means that the police has 24 to 48 hours to conclude their investigation and charge the person to court or release the person on bail. So if the police has refused to release someone on bail within the specified time, 24 to 48 hours, there are things that can be done. The first one is that an application can be made to court for an order of habeas corpus. And then the second one is that the person can, file an action for the enforcement of fundamental human rights. Of course, a lawyer will do that. File an action for the suspect, who is his client or our clients, for the enforcement of the person's fundamental human rights. I told you that, it's a constitutional right. Section 35, subsection 4 of the Constitution provides for this. So an application, and there are also provisions under the Fundamental Rights Enforcement Procedure Rules in Nigeria. So a person can file for the enforcement of his fundamental human rights if he has been held beyond the specified time by the police. An application can also be made to the magistrate to release the suspect from custody. So those are the three things that can be done if a person is being held by the police beyond 48 hours as specified by the law. Police bail would usually lapse upon arraignment. So once the person is arraigned in court, the person will be remanded in custody again and will now have to apply for bail pending trial. So what's bail pending trial? Bail pending trial is an application brought before the court, either magistrate or high court, the court of first instance, asking for the release of an accused person, the defendant in this case, pending the trial and the determination of the case against them in court. Usually it's brought by way of summons or motion or notice. Bail pending trial can be granted in the case of, misdemeanors and felonies. But for capital offenses, it's hardly granted, except special circumstances can be proven. And those special circumstances are that, one, if the accused person can prove, ill health, that's a very serious health condition that would warrant the granting of bail pending trial. Two, if the proof of evidence that's been filed by the prosecution has not disclosed, sufficient evidence, to secure a conviction against the person in the eye of the person's counsel or the person himself, his counsel can bring an application for bail pending trial. The third thing is if the defendant has an alibi that's been successfully investigated by the police, which shows an alibi is a defense in law, which places the accused person in a criminal matter at a different place, at the same time when the offense was committed. So it simply says, for instance, an offense was committed here, I was there, and there's proof to show that I was there and not here. So if a person has an alibi and it's been successfully investigated by the police and shows that the person was at a different place contemporaneously, at the time the offense was committed, an application can be made for bail pending trial. And there's a mistake that many lawyers make, and I'd like to point it out here. When you're making an application for bail, especially for the first instance, that's for severe ill health. I've read a lot of fine bail applications, flowery words, a very long address and all of that, but there's insufficient proof before the court showing that the accused person is actually suffering ill health. Usually you're supposed to attach a doctor's report, disclosing the ill health. You cannot just come before the court and tell the court that your client, that's the accused person or the defendant as you would have it, is suffering ill health and so should be released on bail pending trial. Most lawyers do this, especially in capital offenses where bail is ordinarily not granted, and then you come to court, you ask for bail, and you have not even attached anything showing us that the accused person is actually suffering from ill health. So usually in the judge's ruling, many of those bail applications are usually rejected. So if you want your bail application to be successful on the grounds of severe ill health, attach a doctor's report, preferably a report from a government hospital. So when you attach that, it's proof, that, a medical practitioner, a certified person, an expert, has certified your client, who is the accused person or defendant, as suffering from ill health, and then the court can grant it. So when you don't attach a doctor's report, it's a big blow to your bail application. So if you've been wondering why your application is being rejected by the court, it's probably on the grounds of ill health. It's probably because you have not attached a doctor's report disclosing the ill health, certifying that in actual fact your client is suffering from ill health. So once you bring an application, for bail, the other party, that's the prosecution, will bring their counter affidavit if they are opposing the application. Usually they oppose in capital offenses and probably in some other circumstances, which they would disclose in their counter affidavit. But if not, if they are not opposing, once you apply to court, the court will, decide, make a ruling and decide if to grant it or not. At the magistrate court, you can make a bail application orally, but at the high court, you have to file your application for bail supported with an affidavit. You have to file an application for bail supported with an affidavit and a written address. And if you're filing a counter affidavit too, you have to come with a written address attached. So the court will make its ruling and decide to grant it or not. I must say also that for police bail, bail is free. Bail is free. And what will happen in the instance of an accused person jumping bail, whatever type of bail, police bail, bail pending trial, bail pending appeal, the court would revoke the bail. If it's a bail pending trial or appeal, the court would revoke the bail. The court will issue a bench warrant, for the arrest of the accused person and their sureties. So it's important for you to be sure. If you're standing surety for someone in a bail matter, it's important for you to be sure that the person will not jump bail, because the court can order for your arrest, and also the court can make an order for forfeiture of the bail bond. The third type of bail is bail pending appeal. Bail pending appeal simply means that trial has been concluded and a sentence has been passed, but you intend to appeal it. So you apply to the court to release your client or accused person or defendant from custody, to release them from prison pending the determination of the appeal that you filed on their behalf. So usually bail pending appeal might be granted and might not be granted. Whatever type of bail before the court is subject to the discretion of the court. So there are two things that are weighing against each other. There's the defendant's constitutional right to bail, and then there's the discretion of the court. So those are the three types of bail that we have in Nigeria. If you're an accused person or a defendant, you should know that you're entitled to any of these, whatever stage your matter is at. And if you're a lawyer, these are the 3 types of bail that you can apply for your client at any stage of their case. That's all I have for you today. I hope you've learned a thing or two. Please subscribe to my channel, like my videos, and leave me comments in the comment section. I will see you in my very next video. Toodles. Thank you.